for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. We're prepared to begin argument in our first case, Federal Trade Commission versus Pukey. And Mr. Kozlow, when you're ready.
Yes, Your Honor. Good morning. May it please the court, in light of the Supreme Court's decision in AMG Capital Management that the FTC may not seek or obtain monetary relief under Section 13B of the FTC Act, the monetary relief that the district court granted in two of its orders cannot stand. Those are the orders of March 24th, 2021, awarding the FTC $120.2 million under Section 13B, based on the appellant's alleged deceptive acts and practices, and the order of January 13, 2021, which sanctioned the defaulting appellants in the same amount, also under Section 13B. Accordingly, Your Honors, as the Ninth Circuit did in AMG itself, and as the 11th Circuit did in FTC versus On Point Capital Partners, we're asking this court to reverse those orders, and we're asking the court to instruct the district court to direct the receiver to return the frozen funds and assets to the appellants, and to direct the return of their passports, which have been confiscated. The FTC argues that the award can be upheld under two theories. One, Section 19 of the FTC Act, and second, the district court's inherent contempt power. And I will address each of those in order. Section 19 of the FTC Act does allow for monetary relief if there is a violation of an FTC rule. And the FTC argues that the district court found the appellants violated the telemarketing sales rule, TSR, and they claim that under Civil Rule 54B, there's enough evidence in the record to support a judgment of at least $122.2 million under Section 19. However, the FTC did not plead Section 19 in this case, although it certainly could have, and it has done so in many other cases. Furthermore, the FTC filed a post-judgment motion for leave to amend its complaint to allege claims under Section 19, and the district court denied that motion. Also, Rule 54B cannot be used if it would substantially prejudice the appellants, and in this case, the appellants had no notice in the district court that any claim would be made under Section 19 and no opportunity to defend against such a claim. The claim splitting doctrine would not allow the FTC to sue the appellants in a new case under Section 19, so we submit there's no basis for reimagining this case as if it had been brought under Section 19. In any event, the existing record would not support a $120.2 million award based on the alleged violation of the TSR. As we argued in our briefs, the TSR does not apply to sales of property, only to goods and services. But even if it did apply to sales of property, and even if it were established that there was a violation in this case, Section 19 authorizes monetary relief only if a violation occurred within 3 years of suit, and only to the extent that the district court finds necessary to redress the injuries suffered by those who suffered from the violation of the TSR. The FTC did not put any evidence in the district court identifying any specific consumer who was injured by the alleged violation of the TSR, nor did the FTC put in any evidence to show the monetary value of such an injury. The district court, in addition, specifically said that it would not make any findings concerning any compensation owed as a result of the TSR violation. Therefore, and also the only direct evidence, as we showed, of a TSR violation occurred in 2005, which is 13 years beyond the 3-year statute of limitations in that section. So,
Counsel, are you trying to drag us back into the merits of the AmeriDebt order?
Well, that's the second basis for the FTC's argument is that there's a contempt finding by the district court for violation of the AmeriDebt stipulated final judgment, which was entered on May 17th, 2006. That's the second argument they make. And I'd like to address that as well. In that case, the district court said that the violation began in 2005 and continued because it was based on misrepresentations that were made by the appellants.
Well, what I'm asking you, are you trying to drag us into relitigating the merits of the AmeriDebt order?
No, I'm not, Your Honor.
Well, then what basis do you have? Let's suppose we agree with you on the Section 19 point. Isn't the contempt judgment very different from the merits of the AmeriDebt order are not for us? Does the contempt judgment then become a matter of enforcement and of the district court trying to ensure the integrity of its orders? Because you did violate the permanent injunction arising out of AmeriDebt, which indicated you weren't to engage in false or misleading statements again. And then in the Sanctuary Belize matter, you engaged in the very things that the AmeriDebt order and the injunction said you weren't to do. And I understand your argument under the Sanctuary Belize case and that the monetary judgment might run afoul of AMG, but I wonder if the contempt judgment is really quite different and a matter of the district court enforcing its own judgments. AMG did not affect, it affected monetary judgments, but AMG is very clear that it doesn't affect injunctive relief or equitable judgments. So AMG may get you a certain distance in the Sanctuary Belize case, but I'm just concerned about whether you're trying to impair the district court's efforts to ensure the integrity of its own orders and to protect the sanctity of its own orders, because there is something unattractive about your being subject to a judgment and a permanent injunction and then going right back and engaging the kind of misconduct that the permanent injunction forbids.
Your Honor, I agree that the contempt order is not affected by AMG, and we are not trying to relitigate the AMG final stipulated judgment, nor are we trying to in any way interfere with the court's ability to protect the sanctity of its orders. However, the contempt citation in this case suffers from other defects, not the AMG defect. It suffers from the defect that, number one, it was based on a claim of violation which the district court said first accrued in 2005. Therefore, under 28 U.S.C. 2462, it's out of time. It's way beyond the 5-year limitation prescribed by that statute. Also, in any contempt, if it's going to be a civil contempt, it has to be remedial. In this case, it couldn't be that the purpose was remedial in the sense of inducing the contemptors to comply with the judgment, because it's a 2006 judgment. There's nothing left for them to comply with. It also couldn't be for compensation.
Well, why wouldn't the 120 $1 million judgment, why wouldn't the amount of that be justified in the sense that the violation of the permanent injunction in the Sanctuary Belize case caused the consumers, in the view of the district court, which had conducted a bench trial, had caused consumers $120 million worth of damage. And so it was the violation of the injunction, which would not have been affected by AMG, was as a result of the bench trial. It resulted in $120 million of damages to the consumers in that case, and the monetary judgment may well fall onto AMG. But I'm just wondering if the contempt judgment, which deals with not the merits of this or that, but simply a district court's enforcement powers, predicated on a bench trial. I wonder why that wouldn't be left standing.
Because, Your Honor, the district court would have had to make specific findings about compensation and would have had to tie the amount to the violation of its order. In this case, the district court at page 165 of its opinion specifically said that it found it unnecessary to determine the amount of compensation that any consumer might have suffered as a result of the contempt violation. So the FTC put in no evidence concerning compensation, and the district court made no findings as to the amount, not for 120 million, not for anything.
Well, why weren't the findings made by the district court when, after the conclusion of a bench trial, the district court indicated that the consumers in the Sanctuary Belize fraud had suffered $120 million as a result of the violation of its injunction?
Your Honor, I'll quote the district court's own language. The district court said, and I'm quoting, because any compensatory remedies for the TSR contempt would be duplicative of the restitution ordered for the violations of the FTC Act and the present proceedings, the court finds it unnecessary to determine the exact amount of compensation to be paid by Pookie, Baker, and Usher for their contumacious conduct. So the district court specifically decided not to make any determination, not to make any findings on the amount of compensation that would be due as a result of its finding contempt. And so there's nothing in the record to support an award of $120.2 million for that contempt. And as I say, it's also out of time under 2462. If it's anything, it might be considered a penalty under that statute, or it might be considered criminal contempt, in which case it can't stand because the appellants did not have a criminal trial. The contempt citation against Mr. Pookie separately for $172 million also cannot stand. In that case, the FTC waited until the 15th day of the 17-day trial on Sanctuary Belize to bring up out of the blue an alleged violation of the same stipulated final judgment in 2006 based on his alleged failure not to cooperate with the FTC because he pled guilty in 2010. That had absolutely nothing to do with Sanctuary Belize. And Mr. Pookie wanted to try to offer a response. The district court would not allow him to present any evidence or testimony in rebuttal, and only allowed him to comment on a final argument. Similarly, the FTC put in no evidence to support their claim of this alleged non-cooperation, which had occurred, as I say, in 2010, had nothing to do with Sanctuary Belize.
So you want the $172 million judgment vacated as well?
Yes, Your Honor. And in that case, it's for reasons which I just given, it was either a penalty, in which case it was way out of time, from 2010 to 2018, way beyond 2462. It might have again also been conceded.
Well, I'm unsure of the basis of vacating the $172 million judgment. It seems to us to get back into the merits of the Ameridebt case, which I'm not sure before us, but your client in this case violated the terms of that order by repaying personal loans rather than by repaying the FTC, and you pled guilty later to obstruction of justice. And the obvious remedy for violating the judgment is a reinstatement of the judgment, because it was made clear to you when you consented that if you fail to cooperate with the FTC, the $172 million judgment would stand.
I see my time is up.
Well, you can have some rebuttal time, and if any of my panel has a question, I'll certainly defer.
That question.
Judge Keenan. All right, well, let's
The answer to your Honor's question is that in this
you
case,
know, let's hear from, if the panel has no question, let's hear from Mr. Metzler.
Thank you, Your Honor, and may it please the court. The two orders in this case, affirming two of the orders in this case, resolve most of the issues on appeal. Those orders are the contempt judgment, which has been discussed extensively, and then the default judgment against Mr. Usher and the corporate appellants. Together,
well, why don't you jump right into the question that opposing counsel raised, which is that the $120 million figure that the district court settled upon was not supported by adequate findings.
Sure, Your Honor. At Joint Appendix 1017 to 1018 is the district court's order in which it says that the harm from the telemarketing contempt, and the contempt here was a violation of the Emeridet's order, permanent prohibition on Mr. Puckett and those acting in concert with him from engaging in deceptive telemarketing. Well, the district court found that, and used with extensive findings that that the appellants here did engage in deceptive telemarketing. So that was the violation, and the remedy for that, the harm, the district court said, is exactly the same. The harm is the harm to consumers. So that was the compensatory sanction that the district court entered as a result of the contempt of the Emeridet order.
So I had understood that your colleague on the other side continually sort of made the argument that you say that it's a hurt to consumers, but you didn't march consumers in at all. And so what do we know about these consumers?
Sure.
Do you
So
have a thought on that?
So the I'll start with the assertion, which is throughout their brief, that most of the consumers were satisfied. Well, there is simply no evidence in the record of that. Well, there was one of the consumers was a defense witness who said that. But other than that, the measure of harm in a consumer case like this depends on whether there were misrepresentations made that were material, that were widely disseminated, and then there's a presumption that consumers relied on them. And so the presumption applies here because the district court made extensive findings about each of these misrepresentations, that each of them were material. So then it goes to the defendants to rebut that, and they have to rebut that with specific evidence. Now, it's true there was this one there was this one defense witness, but there were also numerous witnesses from the FTC, including consumers, including recorded calls, including webinars, and other evidence that these claims were made that support the district court's determination that they were material and likely to mislead consumers.
But counsel, is there any place, and I think this is what Judge Motz is getting at, is there any place in this record that we can look to that actually provides a rationale for the amount of damages assessed in the contempt order?
Well, yes, Your Honor, I think that would be in the section of the district court's order that discusses all of this. There's a section that lays out the legal standards, and then there is a section that is titled compensatory, that is entitled, monetary relief. Now that section is describing.
But don't you have problems because some people might qualify, or Mr. Poop could assert a face-to-face exception with regard to some of these transactions? It seems to me it's not necessarily all or nothing. And you're suggesting that it is all or nothing.
So I think it's probably good to clarify here which order that we're talking about. So there is the what I'll call the 13B order, which held that the defendants violated Section 5 of the FTC Act and the telemarketing sales rule, and therefore were responsible for $120 million of monetary relief to remedy that. Separately, the contempt judgment was made for a violation of the Ameridet order, which is not
Right,
based on
but
the
which was
telemarketing-
predicated though on the telemarketing sales rule violation, was it not?
No, Your Honor.
Not at all.
No, so the order itself defines telemarketing, and it prohibits them from making deceptive.
Okay, so you don't think that that's part of the foundation then
It's
for
not,
the
Your-
contempt finding?
No, it's not.
Okay,
The
to what
face-to-face exception is specific to the TSR and not to the contempt.
To what extent are you relying on the court's other aspect of the contempt finding that Mr. Poop paid his lawyer before retiring the judgment?
So
Are you relying on that as well? I haven't heard you talk about that.
in comparison, that we do think that order is correct. That was $148,000 compensatory sanction. So not talking about it because it is a very small amount in comparison to the 120.2 million in the other contempt judgment. So then I'd like to move to, if I may, the
Let me
default.
just say one other thing. What is the standard of review in your judgment of the $120 million finding by the district court
Well, so
on the contempt?
The contempt order is reviewed for clear error for its factual findings, and of course abuse of discretion for the entry of the amount of compensatory sanction. And I don't think that the defendants have shown any abuse of discretion here. And I just like to point to one of the district court's finding. One of the last deceptive claim in this case is that the defendants promised a robust resale market. And what the district court found through a lot of evidence was that there was no resale market. So the defendants say over and over that these properties were worth so much money that that the consumers were not harmed. What the district court found, and they've shown no error in this, is that nobody was able to sell these properties. So whatever intrinsic value they might have had, a property that you have that you can't sell is worth nothing. So the injury to these consumers was the total price that they paid for a property that they were not able to sell. That's even setting aside that they didn't get what they were promised. They were promised properties in a luxury resort with airports and hotels. And
Is it a matter of just pure coincidence that the 120 million contempt judgment matches precisely the 120 million of damages in the Sanctuary Belize case?
No, Your Honor, it's not a coincidence at all, because it was the same conduct that violated the telemarketing sales rule that also violated the Ameridet final injunction.
Well, you
And so-
just said earlier, though, in response to my question, it was not predicated on the telemarketing. The
So
contempt.
it was the same.
So was
conduct.
it or was it not?
Well, it was the contempt is not predicated on a violation of the TSR. That is, they
But
weren't in contempt.
it was predicated on telemarketing, was it not?
That's correct.
Okay.
So they were both telemarketing.
So you're drawing a distinction then between telemarketing and a violation of the TSR.
Right, so the telemarketing violated both the Emeridet order and the telemarketing sales.
All right, so tell me again succinctly now, where you think the basis of the district court's findings were on the $120 million contempt judgment. Just succinctly, what's the basis of it?
So the basis is that that these misrepresentations were made. There is a presumption of reliance that was not rebutted, and the measure of damages in that case is the total price that the consumers paid, and that applies. And then the district court found at again JA 1017 to 1018 that the harm from the telemarketing contempt was the very same harm from the violations of Section 5 of the FTC Act. So between those two findings, I believe, is how you find that the measure of damages for contempt.
Thank you.
Claim that there are two, the amount is not the same. In other words, you're not entitled to 240 million.
No, Your Honor. This is there, and the district court said this
Yes,
directly.
I just wanted to have you tell me that too.
Okay, of course. I'd like to turn to the contempt judgment. I mean, sorry, the default judgments, because the contempt covers the individual defendants here, but the default covers the corporate appellants, and then is a second basis to affirm the amount of monetary relief for Mr. Usher.
Before you do that, remember there's a question about goods and services.
Okay.
And I guess that sort of goes to both now that you told us how they're related to each other. So you want to tell me what the goods and services are?
Sure. So as the cases that are cited in our brief show, when even if real estate is not considered a good and service, this is not a case that involved just plots of land. The consumers in this case were sold, and Sanctuary Police promised them properties in a luxury resort that necessarily included services. For example, in order to have a home in this development, they would need roads to access, and those roads needed to be built. They needed water, they needed electricity, they needed sewer service. All of those were included in what they were purchasing. Those things were not built.
Wasn't there also merchandising, advertisements for these goods and services? I mean, that would constitute a service anyway.
Well, they certainly promised the many amenities which the district court found were not provided.
But isn't it goods and services in connection with?
That's
So
correct. That's correct. So the language of the district of the Meridet order is misrepresentations in connection with telemarketing of goods and services. So yes, they made these misrepresentations, and they were in telemarketing, and the product that they were offering went beyond land and necessarily included.
So what
Offers of financing. I'm sorry, excuse me, Judge Wilkinson. I apologize.
you go ahead, Judge Keenan.
What about the offers of financing that accompanied the telemarketing? Could you address that? How that plays into your statutory analysis?
Yes, well, again, like still talking about the contempt rather than the telemarketing sales rule, so not statutory analysis. But yes, I agree.
No, I'm sorry. Perhaps I'm not being clear. I'm talking about the telemarketing sales rule.
Okay.
And the extent to which the financing would play in.
To the goods and services argument.
Yeah.
Mhm.
Sure.
As opposed to just offering certain future amenities down the line. Was the financing part of the problem as well?
Yes, to the extent that they're offering financing, that certainly is clearly a service, which when bundled with the with the sale of land would qualify and take them out of that exception. To the extent the court wants to address it, as we mentioned in our brief, that this was not, they never brought up goods and services with regard to the telemarketing sales rule specifically. the reply brief does cite one sort of early on filing by Mr. Puckey that mentions, like in one sentence, something about goods and services, but that actually refers to the contempt and not to the TSR. And they
I
never.
think what concerns me at the core of this case is that there was an Ameridet order that and an injunction saying, do not engage in false and misleading statements. And they went right back, and in violation of that injunction, they engaged in the kind of false and misleading statements that the injunction forbid. And the district court held a bench trial as to that. I was familiar with the case, and I do think the nature of the defendant's repetitive misconduct, plus the district court's bench trial, is due some deference. This is at the heart of what the FTC is supposed to be doing, which is cleaning up this kind of fraudulent abuse of consumers. The one thing that I want to make your position, I'm uncertain as to what your position is. I don't think much of your Section 19 argument, I must say, because you didn't plead it, and Section 19 has a number of procedural hurdles which you didn't clear. But one thing I wonder, are you really trying to uphold the monetary award in the Sanction Belize case? Because it seems to me, if you can't switch it over to Section 19, that the monetary award in the Sanctuary Belize case is very likely invalid under AMG. And wouldn't you agree with me that, you know, this doesn't affect large portions of your case? They're not affected by that. But the monetary award in the Sanctuary Belize case would be affected by AMG, would it not?
Yes, Your Honor. I think the monetary award, I'm going to call that the 13B judgment. Yes, that would definitely be affected by AMG. But our argument today is that the same harm is addressed by the sanction for contempt and for.
Well, that's yes, and I understand that, because AMG did not impair the district court's equitable powers, and it wouldn't have impaired the district court's ability to see to the integrity and enforcement of its own order, where the defendants in this case had repeatedly engaged in conduct in defiance of the permanent injunction. But so I look at the monetary judgment as one thing, and I think it's a separate. If I look at the injunction and the violation of the injunction and the attempt of the court to enforce its own orders, I see that as a separate and distinct matter, which was not impaired by AMG. And I'm wondering if I'm correct in that. Aren't you reaching farther than you need to reach in trying to uphold $120 million in the Sanctuary Belize case, the monetary judgment? That's a straight 13 judgment, Section 13 judgment. I don't see how it can stand. And aren't you overreaching in trying to get that upheld?
Well, Your Honor, our argument in the first few pages of our brief is that you do not need to reach those that judgment. And I see my time has expired, but what I'm saying today is the same thing. You say it is it's overreaching, and I'm saying it is beyond what the court needs to decide. Those are the arguments that we make. We think they're correct, but here today our argument is you can affirm these judgments based on the contempt and the default judgment. And you do not need to even reach those issues or decide if they are right or wrong, because the harm is exactly the same. And
Okay,
the-
how do you affirm as to the defaulting parties when you have the AMG problem? And then and it seems to me you're trying to reach the defaulting party. Are you trying to reach them through the contempt route? Or are you trying to use the section 19 to bootstrap reaching the defaulting parties?
Neither one, Judge Keenan. The defaults are in a different procedural posture.
Right, I mean, under Rule 54C, you can't change your theory of the case against them, right?
That's right. But Rule
Right, so you
50
can't use section 19 against them.
No, and we are not suggesting that the court should. Our argument under the default judgments is Rule 55 handles default and default judgment. And what it instructs is you can get relief from a default for good cause. You can get relief from a final default judgment only for the grounds of under 60B. And in this case, they never saw it. They could have. They could have appeared and sought relief from the default or default judgment.
Well, they did
entered.
say that they did file a motion in the district court, did they not, to set aside the default judgment?
To set aside the final default judgment under Rule 60B. Yes, correct. They cited Rule 60B-5, and they didn't really provide any argument as to why they thought that applied. But that the grounds under Rule 60B-5 are generally for judgments that have been either overturned or satisfied. Those don't apply. The only one that could possibly be could apply is that the judgment it is no longer equitable to apply the judgment prospectively. And as we say in our brief, the courts uniformly agree that a monetary judgment that is entered to in response to a past harm is not the sort of prospective judgment that can be that falls under Rule 60B-5. So the only argument that they have alive with regard to the defaults is that one, and it fails under the weight of all of the case law.
But you're saying that's a separate and distinct issue from the other things that we've been discussing, that's just separate and involves a different set of considerations, whether they, showed or whether it was legitimate for pro se defendants to pro se lawyers to represent the corporation. And of course, the default judgment was only entered against the corporation and Usher. So it concerned a much smaller universe of people than the other judgment. It just I think it just involves a different playing field.
I agree, Your Honor, and I should just address, for if I may, the allegation that they were trying to represent these companies as a factual matter that is wholly at odds with how they litigated this case from the beginning. It was to these defendants' advantage to distance themselves from these companies, and that's because our standard, the commission standard that we had to meet to prove their individual liability, depended on their ownership or control of these corporations. So if they are directing the litigation on behalf of these companies, that is inconsistent with their position that they didn't own, that they didn't control these companies. And I'll just give you one example. Mr. Baker repeatedly denied that he owned these companies and claimed that his signature on their founding documents was forged. And you can see an extensive discussion of this at the joint appendix, page 930, where the district court emphatically rejects.
Well, you can't have non-lawyers representing the corporation.
Of course not. No.
And that's one of the things they tried to do, and that's just impermissible.
Right. So the idea that they were that they wish they could have had these companies represented is inconsistent with how they.
All right. Well, if the panel has further questions, that's fine. Otherwise, I think Mr. Corris has 5 minutes.
Thank you, Your Honor.
May it please the court, my name is Gary Karras. I'm with the firm of Barnes and Thornburg, and I represent the successor receiver, Mark Philip Ferzan of Ancora Consulting Group, LLC. I'd like to address two issues pertinent to the receivership. The appellants first contend that because the AMG case precludes the use of Section 13B for equitable monetary relief, that the court must vacate the orders establishing the receivership. And they cite a 11th Circuit decision, FTC versus On Point Capital Partners, in support of that result. The appellants misconstrue AMG and they ignore critical distinctions in the On Point Capital Partners case. And in fact, On Point Capital Partners goes against numerous other cases that have been decided post AMG. First of all, AMG specifically acknowledged that Section 13B permits the commission to obtain preliminary and permanent injunctive relief. And unlike On Point Capital, numerous cases after AMG hold that injunctive relief can be imposed even if monetary remedies are unavailable. And AMG does not suggest that the equitable remedy of receivership is unavailable when injunctive relief is otherwise proper under Section 13B. In fact, AMG never said one word about the equitable remedy of receiverships. And in fact, it's been consistently held throughout the years that receivership is a proper ancillary equitable remedy as an adjunct to injunctive relief, and AMG does not provide otherwise. There's also a critical distinction with the On Point Capital Partners case. It arose in the context of a prejudgment preliminary injunction. We've heard a lot of discussion today about our case in which the FTC has demonstrated that there are multiple monetary judgments that should remain effective that are not based on Section 13B, most specifically the $120 million contempt judgment as to Puckey, Baker, and Usher, as well as the $120 million default judgment against all the receivership entities who did not settle, and John Usher. And there are also numerous stipulated judgments in this case, which preserved the receivership and are unaffected by the appeal, no less than 6 of those judgments, including most recently after the briefing was complete in the case before this court, Luke Chadwick and all his companies settled and has given up his Belize interests and assets. So this is a completely different situation than was facing the court in On Point Capital. The second thing I'd like to discuss is that the appellants assert that the receiver was only appointed to use defendants' assets to satisfy equitable monetary relief. This is simply wrong. The court found at the outset of the case, in connection with the temporary restraining order, thereafter at the preliminary injunction phase, and thereafter at the final judgment phase, that immediate and irreparable harm would result from defendants' ongoing violations of the FTC Act and the telemarketing sales rule, unless the defendants were enjoined. That finding is without reference to monetary relief. And indeed, in each of those orders, the TRO, the preliminary injunction, and multiple final judgments, there are receivership provisions unrelated to asset preservation, and instead are geared to preventing ongoing consumer harm. There's a section that empowers the receiver to remove the officers and directors from control and management of the receivership entities. There's a section that requires the receiver to suspend operations of the receivership entities if in the receiver's judgment they can't be operated legally. And there's also a directive to protect the interest of consumers. All of those provisions are unrelated to gathering assets, and instead they're geared to preventing continued consumer harm. The appellants, in fact, specifically asked the court to, quote, vacate all directives issued by the receiver regarding sanctuary beliefs, close quote. Those directives were undertaken by the receiver to prevent ongoing continued consumer fraud. These include the receiver's instructions for the consumers not to pay under the fraudulently induced contracts, and it also includes the receiver's removal of the board of directors of one of the receivership entities, City River Wildlife Reserve. Those members were appointed by the defendants as part of the wrongdoing in this case. And in fact, this is very similar to the case that came down post-AMG Federal Trade Commission versus Nolan out of the District of Arizona, which we did not cite in our brief. It was entered late last year, and the court found that AMG did not undermine the receivership component of a preliminary injunction order, where one of the key reasons for receivership was.
All right, thank you. Thank you, counsel.
Thank you very much.
Thank you very much. Mr. Coslow, you have some rebuttal time.
Thank you, Your Honor. First, as to the default judgment, it's on page 1022 of the joint appendix. The district court based the monetary portion of the default judgment specifically on section 13B. So that is knocked out by AMG. Cannot be supported in light of the Supreme Court's decision. Second, Judge Keaton repeatedly asked counsel for the FTC to identify in the record where there's evidence to support a showing by the FTC of the amount of compensation awarded by the district court. There is none. There's nothing in this record because the FTC did not put any evidence into the record concerning the amount.
Counsel, let me just say this, that you've thrown up a lot of different issues. I don't know, there may be 20 or what have you. But to me, the core of this case was that you were under a judgment for false and misleading statements. And then in defiance of the court's injunction, you went back and committed a number of very stark and blatant false and misleading statements once more. And again, although there's been controversy about the FTC's role, this belongs right at the center of it. And you say, well, the district court didn't make findings on 120 million. Well, what should the district court have done? For example, the consumers are in very different situations. It's not a one-size-fits-all business. Some of the consumers inspected their property. Others of the consumers did not. Some of the properties were worth more than others. It doesn't seem to me realistic to expect the district court to go consumer by consumer by consumer, drag them all in, see what has which circumstances are the same and which circumstances differ. That's asking a lot. And the district court did hold a bench trial here, made extensive findings about the numerous repeated misrepresentations that were made, and came up with a figure that would approximate the damage that these representations caused. And I can't see sending it back producing any different result, particularly when the district court is much more familiar with the damages imposed or the monetary loss imposed. But the point is, repeatedly you've tried to defraud consumers, and then you come up here and you want to get away with it, and that's I'm having trouble with that.
Your Honor, the first thing the district court could have done was to release some funds that were frozen to allow these appellants to be represented by lawyers. That was an arbitrary and abuse of discretion. The FTC relies on FTC versus worldwide funds. In that case, the district court allowed funds to be released from frozen assets. What it did do was it put a $90 or $40 per attorney cap on the amount that it was allowing. The Ninth Circuit reversed that decision by the district court and said there was no basis to put a cap on the amount of money that could be released from frozen assets to pay for counsel. And it sent it back to the district court and said there should be no cap at all. If there is going to be any kind of restriction, the district court should hold some sort of hearing and have a finding as to how much money had to be kept frozen and how much could be released for hiring counsel. The district court in this case did no such thing. It simply did not give a penny to these appellants represented by counsel. The entire trial and all the findings are based on an unfair trial.
Counsel, then I've misread the record here. I thought there was a small amount at the beginning given to council. That's in error. If I find it in the joint appendix that the district court did do that I'm misreading what it says.
The district court gave $5,000 for living expenses, and the district court made a one-time allocation to some of the appellants of $30,000.
Right.
But that was for travel and for consultation, not for hiring lawyers. The lawyer's bills for one of the lawyers was $136,000. The district court denied any release of money for that. That was just for one attorney and for one part of the case. None of the other appellants were allowed to have counsel. The entire trial was conducted with.
Well, you were here, right? And you're a lawyer, right? So there are lawyers willing to represent these people, right?
There were none in the district court.
There were no lawyers.
There were at
representing
some
them.
point. At some point, there were lawyers. At the very beginning, they had money from their parents or their sister. But once the trial came underway, there were no lawyers representing them. They were acting pro se throughout the entire trial.
So when we go back and look at this massive record, we're going to see that for a large part of it, the district judge, an experienced district judge, prevented you from from your clients from having any lawyers.
The district judge refused to release any frozen funds for the appellants to hire counsel. Yes.
No, that wasn't the question I asked you. But let's not be.
Judge Keenan, do you have any further questions? Can you hear me, Judge Keenan? Do you have any further questions?
No, thank you.
All right. Thank you very much, counsel. We appreciate it, and we will move into our second case.
Please remove your microphone covers.
Please proceed.
Thank you. May it please the court, Mike Charnoff, Scott Perry, on behalf of the appellant. Michael Taylor was a healthy man in his mid-20s in April of 2016 when he went to Virginia Hospital Center for minor routine removal of his gallbladder. Surgery was unremarkable, performed by Dr. Booth. After the surgery, Dr. Booth wanted to order continuous pulse oximetry. We often refer to it in the record as pulse ox. The reason she wanted to do that is because Michael Taylor needed some heavy narcotics overnight to deal with the surgical pain, and because he was seriously suspected of suffering from sleep apnea. As a result, there was a danger he could stop breathing in the middle of the night. So instead of spot check pulse ox, she ordered continuous pulse oximetry. Pulse ox is a simple plastic device. It fits over your finger, clips to your finger, measures the oxygen level. If it drops to a dangerous level, the alarm goes off. Nurse comes into the room, wakes up Mr. Taylor, wake up, bud, start breathing. Or the patient's unresponsive, you apply supplemental oxygen. It is a very simple way of preventing a disastrous result, which is what happened here. Dr. Booth testified without dispute she intended to order continuous pulse ox. At 4:34 in the afternoon, that was what she entered onto the computer entry screen, one of two defects in this product liability. When she entered it, the time displayed said 4:34 in the afternoon. She believed it was going to be taken effect immediately, as soon as he's wheeled off to the recovery floor and to spend the night recovering and under the view of the VHC nurses. That was a design defect. VHC had implemented a default time. Default times are controversial and they're criticized by the experts in this case. But if you were going to apply default time, in this case, 10 a.m. the next day, if you're going to apply a default time, it must be displayed to the user, which in this case is Dr. Booth. She punches in continuous pulse ox. The time comes on the screen 4:34, but that's not what the computer's doing. That's not what the computer's telling the nurses to do. The nurses see to begin continuous pulse ox at 10 in the morning. Well, shortly after 10 in the morning, Michael Taylor was found unresponsive in respiratory arrest and suffered massive brain damage. He almost died. He didn't die. Instead, he's in the condition he's in today. He's an incomplete paraplegic, cannot toil himself, cannot walk independently. This is his life now. The second defect is the order summary screen. Buried at the bottom of several scrolled pages was language indicating the correct start time, meaning according to the computer. But as testified by Dr. Booth, she didn't see it. And as testified to by two of our 7 expert witnesses, who are world-leading experts in these areas of usability and informatics in the EHR field, electronic health record, testified you cannot design the page like that. You have to be able to see all of it on one page, or you have to gray out the button at the bottom of the page, so you cannot say, I approve this order, unless you've actually gone through and reviewed the orders. Usability is defined in the expert reports. I know this is a massive record, but I would respectfully ask at some point if the court would look at pages 65 to 77, the joint appendix. That's Dr. Elkin's report, exclusive of his extensive curriculum vitae and appendices. And Dr. Capel's report.
The summary screen had the correct time in which the blood oxygen monitoring device should be applied. Is that correct?
No, Your Honor. It had the incorrect time. The correct time would have been immediate. It had the time that the default entered by VHC, which is the hospital, that they had entered as a default time. It did reflect the default time of the hospital. It did not reflect the user, which in this case is Dr. Booth, what she intended to happen here with the care of Michael Taylor. And so it's either or works. And let me address this. There's a case that we referenced in our reply brief, which is the Cedar versus Reston Town Center case. It actually came from this court shortly after we filed the opening briefs here, but before our reply brief. And there the court said that this court considers the expert testimony and reports as part of the record, and that's where the trial court hadn't ruled on the Daubert motion. So let me return maybe where I should have started. This is a summary judgment. Summary judgment is a standard that's endlessly litigated, although the standard has not significantly changed in decades. Our burden as the non-movement is a burden of production. It's not a burden of persuasion. It's not our job to convince our particular district court judge that we win. All we need to do is produce evidence, and we produce reams of it. Factual evidence, expert evidence, and under the Cedar case, that is what this court needs to accept in its de novo review of what the jury could choose to credit or discredit.
So you had two claims, two kinds of claims, right?
2 defects, correct.
I thought one was a defect and one was a failure to warn.
Well, correct, legally, yes, there's 2 defects, and then there's,
So maybe you tell us about the expert testimony with respect to each of those.
of course.
I thought I only noticed expert testimony with respect to one of them, so you inform me.
Sure, and I think it's relatively straightforward. From the defect perspective, usability is, or human factors engineering is another term for it, has been employed for decades by NASA, aerospace industry, commercial airlines, and by the healthcare industry since the late 1990s. The whole purpose is to create software that is intuitive, easy to use, that reduces errors. One of the ironies in this case is that this is an error that could not have occurred before the era of the electronic health record. Okay.
I thought that your opponent claims that the hospital had used the software for 6 years and had not lodged a complaint similar to Lowe's with the manufacturer. 6 years of use without lodging a complaint with the manufacturers, that's correct. That doesn't help you, does it?
That's a fact that if I were the other side, I'd argue to a jury, but it's a factual question. This is a landmine that existed in this software for years.
So what we want you to do is to tell us what you would be arguing to the jury, okay? So they have
course.
that, and what do you, I think that's what Judge Wilkinson's getting at. What do you have? I thought I'd asked you that question too.
Let me try to address that
Okay.
directly. What should have been done is quite simple. The defect is hard-coded into the software. In other words, there's some modifiability allowed. So you can add default times, you can change what those default times
No,
are.
I has not been clear. I'm wondering what kind of testimony or evidence or records or something else you had which said that was the proper procedure. If, as Judge Wilkinson says, there's never been a complaint, how do we know? How do we,
Sure.
yeah.
So there's 3 ways to demonstrate product liability in Virginia. It's disjunctive. The district court seemed to struggle with that. First prong is a governmental standard, which we were not pursuing in this case.
Okay.
And the court got quite involved in trying to discuss that. Second is industry standard.
Okay.
And we put up both Dr. Elkin.
Well, but I want you to come back because it would have been you could have introduced this in the summary judgment record. If you've used the software for 6 years, either there has or there hasn't been a complaint similar to Lowe's. Now that's information, there was voluminous discovery in this case. And it would be very much to your advantage to say, wait a minute, there were other complaints lodged, but it's very unusual, it seems to me, for something to be used for 6 years without incident or complaint, and for nothing in the summary judgment record to reflect there is a complaint. And the other question I have is I would think that a lot of other hospitals are using this same software, which seems to address a very common problem during patient recovery. And I kept looking for evidence of similar incidents or similar injuries arising or involving the same problem. And I'm puzzled because if a product is deficient, the hospital would have complained, or there would have been other incidents in the wide universe. You know, the product's liability bar on both sides. They're full of, they, you know, they know what each other's doing. And if a product is under assault or in trouble, there would seem to be a number of suits brought against it or a number of incidents. But I don't see that here. And you have to take into account if there isn't a genuine dispute of material fact, you can, I mean, what happened here was very, very sad. But the question you have to ask is, why should this be laid at the feet of the manufacturer when there are no similar incidents, no prior complaints? I'm having difficulty with that, and you don't want to discourage the development for useful products. And I'm sure this product has been very helpful in assisting plaintiffs' recovery. But I'm surprised, given the grapevine that is the product's liability bar, that we haven't seen more of similar incidents occurring.
Judge, there are similar incidents that Cerner was aware of through the MOD report, which is a government database where they reported other people, including physicians who are users, complaining that the Sorient's order entry mechanism for dealing with default start times causes double testing when it's not needed and no test when it is needed. And the results in delays that are life-threatening. There was a second MOD report that said that the complexities and poor usability of this particular CPOE merits investigation, surveillance, and possible recall.
Was this the same defect identified by Mr. Lowe?
Yes, default times, correct. Also, again, this is all in the expert reports, and we tried to quote them selectively and helpfully in the briefing. The user report cited by Dr. Capel in the MOD database says a defect in Sorient's user interface involving the default start time caused delays in care that are life-threatening and costly. Moreover, in one complaint, another user, which was a physician, complained of similar frustrating issues with orders defaulting to times that were not intended by the ordering physician. So this is a known defect that is being reported by various both mandatory and voluntary reporters to the MOD database, and Cerner produced tickets to us where people had complained that you couldn't make out certain items on the entry screen or that the default times were causing problems. The fact that no one had died before, nor had suffered brain injury before, was simply luck. And remember, one of the other criticisms of this particular CPOE is that there's too many items on the menu. This was sort of the perfect storm. You had the doctor tried to enter it, and it came in as continuous one-time, continuous pulse oximetry. That's what triggers the default to 10 in the morning. So the only way that the hospital would know about it was this particular odd mix of menu choices coupled with default time that's not displayed on the screen, which is the hard-coded defect from Cerner, then results in the patient actually suffering an oxygen deprivation event overnight. All of those things had to line up to manifest for this particular tragedy to happen. But it was there. That's why I used the landmine analogy. The defect was there the entire time. And Mr. Taylor is unfortunately the one that triggered it.
I understand, Mr. Chernoff, but I want to raise a different subject, because another thing that really troubles me about this record is the trial court's misapplication of the Virginia law of proximate causation. And I haven't heard you say anything about it, but it seems to me that that is a threshold error in this case that needs to be addressed.
Agreed. You're right. I'm dipping into my response time, but let me just briefly address it.
I think it's worth addressing if it's a threshold
Agreed.
question.
Agreed. It is absolutely, Your Honor. Proximate causation is always a jury issue.
No, I'm talking about the fact there may be more than one proximate cause, and that it is not the plaintiff's burden under Virginia law to disprove other potential causes. It's only when there's a superseding cause do the other causes come into play to negate proximate causation under the plaintiff's theory.
That's absolutely.
And you haven't addressed that. It seems to me that's a major part of your case.
It is, Your Honor. Let me address it briefly. I was trying to answer the court's questions the best I can. Two related points. One, proximate causation is always a jury question. It's not appropriate for the district court to be weighing evidence or disregarding evidence regarding proximate causation. Second, and coming from the other angle, the reason that we filed an affirmative motion for summary judgment to prevent superseding cause argument is exactly that. You cannot use this empty chair argument. There is abundant evidence, both factual and expert evidence, that this defect is what caused the order to not go through the nurses, which caused Mr. Taylor.
Right, and the court doesn't use the word superseding cause, didn't undertake an analysis of superseding cause in its ruling, did it?
Did not.
Okay, I
You
just
did
wanted to
not.
make sure I didn't miss that.
You did not. Virginia law and the jury instruction that encaptures longstanding Virginia law said there can be multiple causes. And there is, and frankly, it's all part and parcel. In other words, a design defect in a car might exist, but unless you're driving it, it might never manifest. The whole point is that this software is designed for doctors to input orders and then for nurses and other tax and healthcare providers to follow it. And so the notion that they're somehow disconnected doesn't make any sense in the law, doesn't make any sense in the medicine, and the district court completely misapprehended the entire area. I do want to reserve 2 minutes of my time.
All right, thank you.
Good morning. May it please the court,
Mr. Cody, please proceed.
Your Honor. The plaintiff in this case alleges two specific defects. Plaintiff alleges the ordering screen should have auto-refreshed the start time when a physician chose an ordering frequency with the start time other than now. The plaintiff claims that the new start time only displayed on the order list where it was easy to miss because the list could be too long. Now, plaintiff has tried to liken this situation with brakes and a pedal of a vehicle that they get where it's quote unquote hard coded. And they go to pains to explain that it's not like the temperature settings that are configurable. Well, that's not the case here. The situation here, at least with respect to the ordering screen, Virginia Hospital Center bought and knew what it was buying. It was buying a template from Cerner where it would then configure its system to the way that its physicians practice medicine. The system, as delivered to Virginia Hospital, was the initial default for all orders was now. So it was Virginia is now. So all of the orders would have started now. It was Virginia Hospital Center, along with its team of physicians and other clinicians, that chose the frequency once to mean that the order would start at 10 a.m. the next day. If VHC had not made that configuration choice, the order would have started now. VHC could have configured the system such that when the once frequency was chosen, a warning sign could have popped up. That option was available. VHC chose not to use that. Plaintiff here has cited no industry standard that suggests it's unreasonably dangerous to not have the ordering screen refresh the time, and nor could they, because the
Okay, well, Counsel Lynn, are you arguing that VHC's decision not to put a default in is a superseding cause in the case? Or what are you identifying? It seems to me in order to negate their theory of proximate causation at the summary judgment stage, you have to identify as a matter of law a superseding cause. And what have you identified as a superseding cause?
Well, on that point, Your Honor, I think that the proximate cause and cause and fact case law of Virginia actually puts the burden on plaintiff to prove to quote unquote take serious account of other potential causes or offer an explanation for why the proffered alternative causes were not.
It does not. It does not.
Well,
No, counsel. The jury instruction, the model jury instruction in Virginia reads there may be more than one proximate cause. It is a proximate cause which in continuous sequence causes the event unless interrupted by a superseding cause, which in and of itself is the cause of the complained injury. That's the law in Virginia. And if you could please address what your theory of superseding cause is in this case. I didn't really see it in your brief. And it seems to me that the court really made a serious error of Virginia law here in its formulation of proximate causation. And it may be that you've got a really strong case because of all that's going on. And their case may be a loser. in terms of how a jury perceives this, because a lot of stuff went into the mix. I agree with you. But in terms of proximate causation, the district court was wrong. And it seems to me that you have to show that this record contains evidence of a superseding cause as a matter of law in order for you to prevail today. And if you don't, you need to tell us why.
Absolutely, Your Honor. Respectfully, I think that the portion of causation under Virginia law that you're speaking about is proximate cause. It doesn't address cause in fact, which under very clear Ford Motor Company versus Boomer 2013, a plaintiff is required to prove with reasonable certainty that but for the defendant's allegedly tortious conduct, plaintiff would not have suffered the harm. That is plaintiff's burden. That is a completely separate, and well, it goes with causation, but the proximate cause, obviously you can have more than one proximate cause, but in order to get the cause in fact, you must prove with reasonable certainty that but for the defendant's—
There's no such thing as cause in fact in the jury instruction on proximate cause. There's no such thing.
I think it's a component of
Unless the law's changed since I left the Supreme Court of Virginia. It's quite possible that it has. And if so, if you could update.
Yep, absolutely. I think Ford Motor Company versus Boomer, it's 736 SE 2nd, 724, 2013.
Right, that's not the Virginia Supreme Court.
Yes, it is.
Excuse me. Okay, well then I have okay, I need to get back to you on that.
I think
Because
now you've convinced me I might not, but
I don't think they were ruling on superseding cause.
they were not ruling on superseding cause.
Exactly.
I agree. So,
Okay.
So in terms of superseding
Okay.
cause, so I think
So let's dial it back then. And I'm sorry that I misapprehended the source of your site, but you still have to identify a superseding cause as a matter of law, okay? In order for you to prevail on summary judgment, do you not?
I don't agree with that, Your Honor. I
Okay,
think that initially it is plaintiff's burden to come forward by a preponderance of the evidence to prove that, but for the defendant's
right. Assuming that they have shown a proximate cause, then don't you have to show, and I understand your argument as to why they haven't shown a proximate cause. But once they have shown in the record a proximate cause, don't you have a duty then to show, aren't you required to show a superseding cause as a matter of law in order for you to prevail on summary judgment?
I agree with that.
Okay.
I think that's correct. But for the
Okay,
reason that
the judge in this case didn't address superseding cause, did he? Judge Hilton?
well, the court did not, Your Honor, but I think
Right. So how have you prevailed as a matter of law on the issue of superseding cause when the district court didn't even address whether there was a superseding cause?
Your Honor, we didn't have to get to superseding cause because the court found plaintiff could not even offer evidence of proximate cause. They could not meet that initial burden. So what you just described, Your Honor, was the assumption that they could in fact prove that. And that's what the district court explicitly found they could not prove. They couldn't prove it because their experts could not, and actually explicitly did not consider all of the other multiple sources that could potentially be the potential causes. And that's why it's important to go back to the Ford versus the Boomer case, because
But
again,
weren't their experts essentially saying that this product did not meet consumer expectations? I mean, wasn't that the thrust of what their experts, whether you accept it or not, whether it's strong or not, isn't that what the experts were saying?
can you say that one more time? This first part.
Pardon?
Can you say that one more time? I apologize.
Yeah, no, isn't what the experts were saying that the product failed to meet reasonable consumer expectations? And that's how that was the prong that they sought to prove failure to warn under. Now, you could say that their evidence wasn't strong, but it certainly was disputed on that part, was it not?
So a couple things on that, Your Honor. So the reasonable consumer expectations there has to be some actual meaningful standard that you can gauge that against. Here,
With respect to causation, isn't your argument that plaintiff's view of causation in Virginia law certainly recognizes that there can be multiple causes? But your argument would have to be that the plaintiff's view of causation is simply not plausible enough or realistic enough to create a genuine issue of material fact, and that the overwhelming weight of causation does not lie with the manufacturer, but with the physician and with the hospital staff and the like. I mean, that's what it seems to me that's what you have to say, that plaintiff's view of causation is simply not a realistic one. And part of your case would have to be if I don't know whether this is disputed or not, the fact that the hospital had used this for 6 years without reporting, without complaining to the manufacturer, and there's an absence of many similar incidents. But you need to go sort of realistically at the whole question of causation and say why the plaintiff's view of causation doesn't create a genuine, an issue of triable fact. That's what you need to do. And you need to sort of maybe put aside the terminology and just get to the practicality of it, which is that their view of causation simply does not rise to the level of genuineness needed to create an issue of triable facts. So why don't you talk about that?
Yes, Your Honor. So the record's clear. There is no dispute that the system was used for 6 years with no incident. The MAUD reports that counsel discussed, those were not weighed by the district court, but were in fact, the court concluded that it couldn't rely on those for previous notice because plaintiff's experts were unable to say how those systems were configured, such that they had no basis to say whether or not the defect was the same or the events giving rise to the particular circumstances were substantially similar. Going back to your question, Judge, as to causation, I think it's a proper analogy and hypothetical would be like in a medical malpractice case or a product exposure case where you have to rule in and rule out particular possible alternative causes. And if plaintiff would have alleged or made the argument that it was Cerner's EHR plus the doctors plus the nurses plus all of these other factors that were a cause, you could have multiple causes. That would be, we wouldn't be here today, but they never did that. They instead came forward with one claim against Cerner, said, you are the but-for cause, which, as for all the reasons that we've been talking about, they could not prove because none of their experts had considered any of these other multitude of possible causes.
Okay, but getting back to the Ford Motor case, and now I remember, that was a mesothelioma case, wasn't it? Okay, so the issue wasn't a system that required input. You know, you've got a lot of moving parts in your case, and that's why I think it makes it really hard for the plaintiff in front of a jury when you have a lot of moving parts. But in that case, it was, you know, what was the cause of the mesothelioma? Okay, was it caused by something else or was it caused by this? In other words, was this really the proximate cause? So the court in that case wasn't talking about a superseding cause. It was talking about the quantum of proof required to show proximate cause, was it not? I know you've airlifted the quote, and the quote really helps you. But when you put the quote back into context, and you don't have an issue of multiple causes that undeniably contributed to this situation or this injury, okay? You have a situation, what was the cause of the mesothelioma? And the defendant's theory wasn't that there were 5 other things that contributed to it, okay? And so it seems to me that, you know, you get back to the original problem that you had in the case, which is the fact the court wasn't analyzing superseding cause. Now you're saying, I want to make sure I understand you correctly. You're saying none of that matters. The court may have bungled the law of approximate causation, may have failed to address superseding cause, but notwithstanding all that, the plaintiff's evidence was insufficient to show it was a proximate cause of the injury. Is that correct?
That's correct.
Okay.
That's correct. I think because I think the case law in the Boomer case agreed it was a mesothelioma case. The court was or confronted with whether or not to adopt a substantial cause analysis, rather, or substantial cause, approximate cause, rather than but for. And the court said we are going to continue to use the but for cause for all cases except for those where there are multiple approximate causes. Plaintiff here hasn't alleged there are multiple approximate causes.
But I understand, I mean, Judge Keenan is certainly more conversant in Virginia law than any of us here. I respect that. My only, and I'm also prepared to believe that the district court did err and make an error in not addressing the question of superseding cause, and I'm certainly not averse to pointing that out. But plaintiff is still left with the burden here of creating an issue of triable fact as to causation. And the problem I have is that with so many thousands of people who have used this system correctly, and plaintiff's view is, well, the doctor was just too busy to notice what was on the summary, what was on the summary screen, that the health professionals were too busy to notice. Well, that doesn't seem to me to help their case. This particular device has been utilized probably hundreds of thousands of times correctly and has helped with the process of patient recovery. And my thought is that given that, there are so many other people who were responsible for what happened here. Doctors, nurses, staff, and I can't believe that they were as neglectful as they were. And that to me just doesn't, it still doesn't point to a theory of causation that would say that the manufacturer, and I'm just wondering that the manufacturer was the cause here, and it's still plaintiff's burden to create an issue of triable fact. And I realize they're experts and everything, but this whole thing could have been cleared up so easily with just a little bit of attention on the part of the hospital staff. That it seems to me is what you have to argue. Not that the district court was correct, because I defer to Judge Keenan completely on that, and that it was not correct in failing to address the issue of superseding cause. But even given that failure, is there an issue of triable fact here as to causation?
And there is, Your Honor. I think that the record demonstrates, even setting aside the actual EHR that was used here, setting that aside, Dr. June was one of Mr. Taylor's physicians. He entered a handwritten note that Mr. Taylor should receive pulse oximetry. The record is that it was either not conveyed or it was ignored. Secondly,
what does that prove with respect to this plaintiff and this case? Because it seems to me that shows that maybe there was negligence by something else, somebody reading the chart. I don't know what that proves here.
Right, you can't, well, I think it goes back to, you can't prove but-for causation where you haven't actually considered or addressed any of the other potential causes. You can't, it's rule in and rule out. You have to first identify that these are the potential causes and say either why they are potential causes or that they're not.
Well, was that done? I thought with your whole dialogue with my colleague, we demonstrated it wasn't done. So you're conceding now the analysis of the district court is incorrect.
I'm saying that there are multiple reasons why the district court could have come to the conclusion that they couldn't meet causation because they hadn't considered and they hadn't ruled out potential causes as required. Their experts can't come in and just claim a singular event is a but-for cause and completely ignore all of the other potential
But
causes.
isn't a problem perhaps, and I'm not sure, the fact that the district court had a pending Daubert motion and didn't consider it. So don't we have to consider the record as it is now without and accept these experts at their face value, even if perhaps they would not, the plaintiff would not have prevailed on the Daubert motion?
See my time's expired. May I answer the question?
Mhm.
So I think to that question, Your Honor, the experts explicitly said they did not look at any of these other potential causes. Recall that Mr. Taylor had initially settled his malpractice claim with the hospitals, subsequently brought this case as a brand new case just against CERN. So it's the experts did not consider Dr. June's order, all of the other potential possible alternative causes. Instead, they
Did they have to in order to determine whether this was one of several proximate causes?
Absolutely. You can't say something is a but-for cause if you don't consider the possibility of anything else. That's not the way that any of the
No, I'm just thinking about in terms of summary judgment. I guess I'm a little hung up here on the fact that there was no Daubert hearing. And these experts seem to say enough to push it just barely across the line on this record, even though they may not have held up on Daubert motions. And so what do we do?
Yeah, well, I think you can affirm because the district court recognized that simply identifying one potential cause out of a myriad of other potential causes can never meet the but-for standard set forth by the Virginia Supreme Court.
Are there any further questions?
No.
All right, well, let's turn to Mr. Sharnoff, who has some rebuttal time.
Thank you, and I will try to make the most of my short time. Just beginning with the proximate causation issue briefly, we did refer to the Ford Motor Company versus Boomer in our, I think it's our reply brief, and it says, quote, where concurring negligence of the two produces a single injury and each is a proximate cause, they are both liable. And again, this is citing case law that goes back over 100 years in Virginia. I want to address this notion that answer the last question that was addressed. Virginia law does not require our experts to rule out causes that are outside of what caused the injury here, as long as
Your expert does have to say affirmatively that this was a but-for cause.
Correct, and they have done that. And I'm also going to point out that in their respective reports, Dr. Elkin and Dr. Capel, they made it clear that in forming their opinions, they were aware of and considered the actions of Dr. Booth, the hospital, and the VHC nurses, and that they made clear that none of their actions affected their opinion that Sorian's defects was the proximate cause. Yes, I'd refer the court to the joint appendix, pages 67 and 68, which is one of the expert reports. It's Dr. Elkin, and also take a look at 259 and 261 of the joint appendix, which is some of Dr. Capel's opinions. I'd also refer briefly the court to 2956 to 2957. Again, these are all where the experts considered the actions of the healthcare providers. And again, and I know I made this point earlier, but when it comes down to it, it's all part and parcel. This is not in a vacuum. The whole point of electronic health records is to make it less likely that you make error, that there's more accuracy, not that there's less. There is a passage in the expert reports that specifically says this type of error did not and could not happen without the introduction of this defect. It's absolutely a but-for cause. Our client would not be in the condition that he's in.
Okay, Mr. I'm not sure how to pronounce his name, and I apologize. Rolcott is, thank you, is though sticking with that line from Ford Motor Company. And, you know, I pointed out the factual distinction that you didn't have a lot of different causes at issue. And he's saying that doesn't matter. Would you like to address that?
It doesn't matter. It's not what the law said. The law says that multiple proximate causes can exist. This is why we've had the jury instruction we've had as long as we have. The reason, and again, and I want to address this briefly, we filed our own summary judgment, which was non-dispositive, but as to the superseding defense, they have not elicited the factual evidence, certainly not the expert evidence that they would need to mount a superseding cause defense. Perhaps it's one of the reasons that the district court perhaps didn't address it, but those experts clearly won't qualify. And I mean, we'll get there when we get there.
I don't think,
I'm sorry.
excuse me, Judge Keenan, you go ahead.
No, once the district court jumped the track on proximate cause, then it and thought that it needed to rule out these other causes, then I guess if you accept the district court's analysis, it wouldn't have had to get to your motion, would it?
And let me make sure I understand your question. If they would have accepted that we'd already made the
Yeah, I mean, I agree with you that
Okay.
the district court misanalyzed the law of proximate cause.
Okay, thank you.
But if some of the other judges disagree with you, then where are you left with the district court's failure to address your motion? In other words, is it really a problem if they disagree with you on the primary issue?
Procedural posture, no. I think I
Yeah.
understand your question now.
Right.
Thank you. Took me a moment. I'm sorry, you had another question?
You keep talking about there can be multiple proximate causes. And I don't think anybody disagrees with that. There absolutely can be multiple proximate causes under Virginia law. But Virginia law also, product liability law doesn't require the safest conceivable design. And I'm not sure that the question of design defect has ever been located with enough precision. And even given the fact that there are absolutely proximate causes, that doesn't relieve a plaintiff of the burden of showing an issue of triable fact as to the cause, as to the manufacturer's role in the chain of causation, because causation is a crucial element. In your case, it's absolutely crucial in all products liability cases. And what troubles me is that even apart from the design defect, which is sort of hazy in my mind, or the failure to warn theory, which I'm not sure would have corrected anything, the question still as to causation is whether your view of it is plausible. And on this point, given the large number of people on the front line who were responsible for something as important as blood oxygen monitoring, to lay this at the foot of the manufacturer when there were repeated oversights and sloppiness and everything else on the part of the hospital staff and the physician, it seems to me thin. I know that the manufacturer has the deep pocket here. And I know that, as I say, what happened here was very sad. And I realize that the $2.2 million settlement, Medicaid may pay the medical expenses, but I understand that there are a large number of non-medical expenses. And I understand why you want to get at those. And Cerner is the party with the deep pocket. But I guess it all comes down to the fact that I think the evidence on causation against the manufacturer is really thin. It's just a judgment call. If I thought it was stronger, I would say this should go to the jury. And I'm not prepared to say that the district court handled it correctly, or it did commit the errors that my friend Judge Keenan has pointed out. But granted all of them, it seems to me that the evidence as to a critical element of your case is pretty thin.
Judge, my time is up. May I briefly respond?
Sure.
Thank you. The healthcare providers here were misdirected. They were misdirected by the product defect. Dr. Booth intended and testified without contradiction. She intended for this patient to get continuous pulse ox. That was subject to a default, and those nurses were not ordered to actually begin the care until 10 o'clock the following morning. It is a direct but-for causation. But for this design defect, this would not have happened. And just to finish my response, directing her to page 12 of our reply brief, we once again summarize the industry standards, specific industry standards that both Dr. Capel and Dr. Elkin refer to, the NISTIR standards and the HIMSS standards. They're specific elements of design that was violated by having the wrong start time displayed on the screen. It's a simple error. When we click out of Microsoft Word, it asks you, do you want to save the document? And a simple pop-up wasn't there. The wrong time was displayed on the screen, and this horrible thing happened.
All right. I think you're omitting disadvantageous points in the record, but I'm not going to go over it and over it. Thank you very much, Mr. Charnoff and Mr. Dirokati, and appreciate your presentations. And now we'll move into our last case.
Thank you all very much.
And please remove your microphone covers.
court. The government doesn't dispute that Donzel McKinney's 924C conviction is based on the unconstitutional clause of that statute. Instead, its only defenses to McKinney's motion to vacate or procedural default and waiver. But recent decisions from this court resolve both of those issues in Mr. McKinney's favor. First, the government's procedural default defense fails under this court's decisions in United States versus Jackson and N. Ray Thomas. Jackson isn't distinguishable from this case in any meaningful way. Like McKinney, Jackson was challenging a 924C conviction based on Davis. Like McKinney, if Jackson had prevailed on the merits of his claim, he would have demonstrated that he was convicted under an unconstitutional statutory provision. And in Jackson, the government raised a procedural default defense similar to the one that it raises here. This court held that the government's procedural default argument failed in Jackson because in Thomas, the court had held that the Supreme Court's decision in Davis established a new rule of constitutional law made retroactive on collateral review. Furthermore, in Thomas, this court concluded that before the Supreme Court decided Davis, a Davis-based argument was unavailable to the commission. So for the same reason that the government's procedural default argument failed in Jackson, it also fails here. McKinney has established cause because Johnson and Davis-based arguments were unavailable to him at the time of his conviction and direct appeal. And he's established prejudice because he's been convicted and sentenced under an unconstitutional statutory provision, and that is an actual and substantial disadvantage. McKinney also established actual innocence.
When you agree that there, I mean, one of the things that this case seems riddled through with not only procedural defaults, but waivers. You have an initial waiver in the plea agreement not to challenge the conviction on sentence, and then you never brought up in the Davis challenge the time of conviction, sentencing, or direct appeal. In other words, we have here both waivers and procedural defaults. And so you can only get around that by establishing cause and prejudice. Is that where we are?
That's where we are. Of course, actual innocence is another way to get around the procedural default, but it's clear based
You're
on
not ending actual innocence because Bowsley requires factual innocence.
that may be the case, Your Honor, but it doesn't matter in this case because under Jackson, Mr. McKinney establishes cause and prejudice. Cause because Johnson and Davis-based arguments were unavailable to him at the time of conviction and direct appeal, and prejudice because he's been convicted and sentenced under an unconstitutional statute. And with respect to the waiver issue under United States versus Cornett and United States versus Beck, McKinney's challenge to his 924C conviction falls outside the scope of his post-conviction waiver and his plea agreement by operation of law. And that's because everyone agrees that his 924C conviction is based on the unconstitutional residual clause, so it was beyond any court's authority to convict him under that statutory provision. So just like the defendant in Beck, he's arguing that no court in any case can do what the district court did here. So consequently, Cornett and Beck control here. The government's waiver argument has no merit under Beck. So the government makes a lot of arguments in its brief, but none of them can evade this court's decisions in Thomas, Jackson, Cornett, and Beck. And in fact, the government hasn't even attempted to distinguish Jackson or Beck. It completely ignores Beck, and with respect to Jackson, its only argument there is that this court's ruling on procedural default is not actually a holding of the court, which is not.
One question I have in terms of prejudice or actual innocence or whatever. One of the things that the courts look at with respect to guilty pleas, prejudice is measured by whether there was a reasonable probability that the defendant or the petitioner here would not have pled guilty. And I went and reread the pre-sentence report here. And when the restaurant was robbed, one of the women in the restaurant was hit in the head by McKinney and other females outside the restaurant. A gun was put to their head. Robinson was ordered, a witness was ordered inside the restaurant. He discharges a firearm. And these facts of the use of a gun in the course of the robbery are so vivid that if this individual had gone before a jury, the result would have been devastating. It would have been a duck dead in the water. And so if you look at prejudice in that light, given the fact that no objection was raised to those very sad and actually traumatic facts in the pre-sentence report, how can we say that there's prejudice in the sense? There are a lot of ways you can look at prejudice, but how can we say that there's prejudice in the sense that there's a reasonable probability he would not have pled guilty? He got a good deal.
Well, actually, Your Honor, your comments point in a couple of different directions. First of all, the facts of the case, those are directed toward the actual innocence question. And actual innocence and prejudice have to mean something different, because Bowsley says that there are two ways to get around procedural default. Cause and prejudice is one, and actual innocence is another. So prejudice can't be judged by actual innocence.
By what?
Well, the standard that you're referring to is a standard that's used in effective assistance of counsel cases. And that is not the standard that we apply here. Really, the standard should come from Frady, which is an actual and substantial disadvantage. And in this proceeding, he was only charged with two offenses, one of them being the conspiracy and the other one being the 9/24.
Well, I don't know why we wouldn't apply that here, because whenever we have a case where someone is seeking to withdraw a guilty plea, the Supreme Court has been asking, well, is there a reasonable probability that they would not have pled guilty? And given the facts, unobjected to facts in the pre-sentence report, this is exactly the kind of crime that 924C is aimed at, which is the use of a gun in the course of a Hobbs Act robbery. And a jury trial would have turned out very poorly from your client's point of view, and the result would have been far less favorable than the guilty plea.
Well, Your Honor is even getting away from the question of whether he would have pleaded guilty absent the court's mistake. And again, you're talking about actual innocence, and that's something different from prejudice. Furthermore, even if you look at the question whether he would have pleaded guilty, the facts in this case and the record from the two failed plea hearings plus the final third one demonstrate that actually Mr. McKinney wasn't willing to plead guilty to the substantive Hobbs Act robbery or the 924C predicated on the substantive Hobbs Act robbery. So that even that standard doesn't ring true for him, because he had a problem with pleading to the substantive Hobbs Act robbery.
Well, there's the additional point that the plea was a pretty good deal, and how can there be prejudice if the government dismissed in return for a guilty plea to the conspiracy, the government dismissed the substantive count. And if he had declined to plead to the conspiracy, Hobbs Act conspiracy, at a time when that was still considered a crime of violence. That's been overruled now. But how can there be prejudice? Because there's no way the government was gonna, in this case, given the facts, dismiss the substantive Hobbs Act count if the defendant was not going to plead guilty to Hobbs Act conspiracy. It seemed like a pretty decent deal.
Well, Your Honor, I question that. Why was this a good deal? He got exactly the same thing from the information plea agreement that he would have gotten from the original plea agreement. So I disagree with you that it was a good deal. And furthermore, if he had only pleaded guilty to the conspiracy to commit Hobbs Act robbery, all of the gun conduct would have come into consideration through the guidelines. So it's entirely possible that he would have gotten exactly the same sentence if he had only pleaded guilty to the conspiracy.
So really, I think maybe you're talking past Judge Wilkinson a little bit when you're talking about what is the prejudice here. And let me make sure I understand your argument. As I understand your argument, you're saying the prejudice is he was convicted of an offense that no longer qualifies as a violent felon. Is that correct?
Well, the prejudice is that he was clearly convicted under the unconstitutional residual clause.
Right,
So his conviction
Right. So
violates.
it no longer qualifies.
He no longer qualifies for the 924C conviction that was alleged in the information that he pleaded.
Okay, and then what Judge Wilkinson's suggesting is an alternative theory, I think. Well, even if he has a constitutionally defective conviction, because it was predicated on that clause, what about the fact that he didn't object in the PSR to this evidence of the robbery? Why isn't he stuck with that? How can he claim prejudice if the unrebutted evidence in the record is that he committed a robbery?
Well, for one thing, he gave up his trial rights by pleading guilty, and those certainly have some value. And in fact, I think it's the Davila case where the Supreme Court recently talked about how important those trial rights are to a defendant, and he wasn't going to waive those if he was required to plead guilty to a 924C predicated on substantive Hobbs Act robbery. But I think the interesting thing about this case is there actually was an indictment that was fully dismissed and then a subsequent information. So there really was nothing left in the information for him to plead guilty to except for the conspiracy once the 924C falls out. So that's another reason why in this proceeding, it was prejudicial to him that he was convicted under this.
See, the difficulty I'm having with that, somewhat along the lines that Judge Keenan has suggested, you can get around the clear procedural default with cause and prejudice, or you can get around it with actual innocence. And it seemed to me when you were talking about he pled guilty to a crime that legally is not recognized because the crime of violence, Hobbs Act crime of violence, is no longer, conspiracy is no longer a crime of violence. But it seems to me that your argument runs into headwinds over the difference between factual and legal innocence. And I thought when reading your good brief that you were putting really the subtext of it, or the emphasis of it, was on the legal innocence. And I think Bowsley is a very difficult case to get around because Bowsley is dealing with factual innocence. And it's in this difference between legal, quote, legal innocence and factual innocence that's very important, because the facts here, as described in an unobjected to pre-sentence report, they're absolutely damning. And they're very they're very horrifying. It really was quite a brutal offense, which lies right at the heartland of 924C. So I that you've put forward allow you to get around the procedural default and the waiver, and there are all kinds of. I've seldom seen, and haven't seen too many cases where they're both waivers and procedural defaults, which are meant to ensure a certain degree of finality to criminal proceedings, not complete finality, but a certain degree of finality. And I thought you were trying to circumvent the procedural default with something that sounded to me like actual innocence, and the facts are very, very difficult, I think, for you to overcome. I want to give you the last word. So whatever you have to say, I would appreciate hearing.
Well, I think that it's important to remember that under Bowsley, there are two different ways to avoid procedural default. And one of them is cause and prejudice. And this court's decision in United States versus Jackson is on the books saying that the government's procedural default defense fails in that case, even though that in that case, the court held that the petitioner's conviction was actually not under the residual clause. So really the question is there a way to distinguish Jackson from this case? And the answer is there's not. If Jackson's claim was not procedurally defaulted, then Mr. McKinney's claim couldn't have been either.
Can you tell me though, in words, what the prejudice is?
In words, the prejudice is that he has been convicted and sentenced to 10 years imprisonment under a statutory provision that's unconstitutional.
Right. But if he had pled guilty to exactly the same thing in another, there wouldn't have been any prejudice, right? I mean, in other words, if he had an equal crime that he had committed and an equal sentence, you couldn't say that this one, it wouldn't amounted, everybody would agree that would just come to the same sentence. Then there wouldn't be prejudice. I think that sort of gets at the heart.
Maybe that would be true if he had demonstrated a willingness to plead guilty.
Well, so take this, just assume here, which I think is where Judge Wilkins' questions have been leading you, that the record here shows that he would definitively been convicted of and receive the same sentence. So what's wrong with saying that that shows that there is no prejudice?
I think what's wrong with that is that is the actual innocence inquiry, which has to be something different than the prejudice inquiry under Bowsley. So if you are substituting an actual innocence inquiry by looking at the facts of the case to see whether another count would have been constitutional, then I think that you are engaging in the actual innocence inquiry, and you're also engaging in the inquiry, the Lewis versus Peterson inquiry, which asks whether any equally serious dismissed charges as opposed to more serious dismissed charges under Bowsley, whether the person would be actually innocent of those as well. And that can't be the test because, as I said, prejudice has to mean something other than actual innocence of Bowsley.
Well, but by the same token, does it mean, it would seem that prejudice has to mean something different than cause. And I'm not sure that under your analysis it does.
Well, prejudice does mean something different under cause, because under cause you're looking at what Mr. McKinney did or didn't do, right? But under Frady, under prejudice, you have to look at the court's error and what difference did the court's error make, not what Mr. McKinney failed to do. So by looking at whether he would have pleaded guilty or not if he had raised the objection in the district court, you're looking at the wrong question. You're looking at what effect his failure to raise the issue had, as opposed to what effect the court's error in convicting him under a unconstitutional
Do you have
statute.
Fourth Circuit law on that particular point?
Supreme Court law, Your Honor, United States versus Brady, very specifically says that under the prejudice analysis, you look to the effect of the court's error.
But on this, there have been a million of cases like this. And what I'm talking about is this statute and this kind of.
You mean in the Davis
I mean,
litigation?
I found district court cases. I found unpublished opinions. I haven't found.
Right, I think that's true. There are not published decisions from this court, except for Jackson. And I think that there are a couple of reasons for that. I think one reason is in many cases, the government doesn't raise these procedural defenses. Another reason is because many district court judges have already found cause and prejudice, so there's no appeal. And then a third reason is because this court has to grant a certificate of appealability. So in a lot of these cases where the predicate offense, actually, the court can look at it and say, oh, this is definitely a crime of violence, and the court just doesn't grant a certificate of appealability, and it just denies the appeal in a very short 2 or 3 sentence statement saying the court denies a certificate of appealability. I think that is why, despite the number of these cases that have occurred, there are a lot of
others that we don't hear.
Right.
Okay. So
Thank you very much, Ms. Hester. You
Sorry.
have some,
Judge Wilkinson, I just have one more.
oh, absolutely. Excuse me, Judge Mott.
I wonder if you could address the 28J letter. Government.
About the Gregorowitz case.
Yeah.
So, yes, I have given that some thought. And I think that the most important thing to note is the court decided that case without granting cert. They do that sometimes. They grant cert and summarily per curiam issue an opinion. They didn't do that in that case, which means that they never took jurisdiction over it under 28.
I've never seen another thing like this.
Well,
Have
it's
you?
very unusual, but I don't.
Have you ever found another?
No, I've never seen it. But so that's my first point. I don't think the court ever took jurisdiction of it to issue a decision on the merits under Gregorowitz, or however you say it. I think the other point is the whole discussion between the statement and the dissent was all about whether it was appropriate to grant a GVR when the government wasn't arguing that the Court of Appeals had made a mistake. And you can see that in the statement and in the response. I mean, nobody thinks that this is a ruling on the merits on that waiver issue.
Well,
except for the government.
No, that's not true. If you look at the statement from Justice Kavanaugh, he says, because the Seventh Circuit correctly concluded that defendant's additional guilty plea precluded any argument based on the new case law, this court has no appropriate legal basis.
Yes, and I guess my point is, if Justice Sotomayor had thought that that was a ruling on the merits, she certainly would have mentioned that in her response. But I think the reason that it's not is because the statute governing cert under that statute.
I get what you're saying, but 5 people joined that statement,
I know,
and all 5 of those people are on the Supreme Court.
I know, but my other point is, well, it's not a ruling on the merits because the court never took jurisdiction over the case.
Okay.
And
Don't you think that's a pretty good signal to us?
maybe not, because the issue is entirely different in that Seventh Circuit case. That was all about whether actually the guilty plea itself, not the plea.
Yes, it's true. They are different, but the scope of this sentence is not.
They're different. I think it's possible one of them would change their mind after briefing on the merits. That's why the court has briefing on the merits. That issue just really wasn't explored in the cert petition, and certainly not in the government's response, which was just simply asking the court to vacate, grant, vacate, and remand.
All right, anything further?
Thank you.
Judge Motz, Judge Keenan, do you have any further questions?
I think.
Mr. Enright?
Thank you, Your Honor. May it please the court, Anthony Enright for the United States. The district court properly dismissed McKinney's 2255 motion because his guilty plea resolved a valid 924C charge, of which he is undisputedly guilty. I will talk about procedural default first.
As he's pled guilty to it, that's how he's undisputably guilty.
I'm sorry, Your Honor.
he pled guilty to it, or there was a jury trial,
Oh,
or how is he undisputably?
He's
guilty?
undisputedly guilty. The defense has not disputed that he is guilty of that offense. Took from the acceptance of responsibility point at sentencing through today. And in fact, the defense filed a brief as recently as August saying, I had no reason to dispute the district court's finding that the outcome would have been the same had he raised this issue during his criminal case. I don't think the defense has ever disputed his guilt of possession of a firearm in furtherance of a substantive Hobbs Act robbery, which remains a crime and a crime of violence today. And I think that's highly relevant because it's relevant to the procedural default question. You do have to show prejudice. There's a big difference between, I agree, there's a difference between innocence and prejudice. Prejudice refers to, is the outcome different? Would the outcome have been different?
Would possibly.
Would have possibly been different. The defendants would have the burden there, and you have to show actual prejudice. And under either standard, if the question is, would he have been convicted after a trial? Then he can't show prejudice because he doesn't dispute the facts that would establish his guilt. And his most recent his August brief actually concedes that he would have been convicted. And if the question is there a reasonable probability that he would have pleaded guilty in any event, then the answer is the same. He did receive a good deal. He received 3 points off of his guideline score for acceptance of responsibility and the dismissal of 1 count in exchange for his plea of guilty. And had he proceeded to trial, he wouldn't have received either of those things. He would have had to proceed to trial under the original indictment, which charged 3 valid offenses, including a 924C predicated on substantive Hobbs Act robbery.
I'm not certain exactly what the standard for prejudice is here. It seems to me that the absence of prejudice could rest on 2 multiple theories. Number one, the undisputed evidence in the pre-sentence report, being just right at the heart of 924C, but prejudice could also be indicated by the lack of prejudice could also be indicated by the fact that the government would not have consented to the dismissal of the substantive Hobbs Act count if the defendant had refused to plead to Hobbs Act conspiracy, in which case the defendant would have been conceivably in a worse position, but in any event, in a no more advantageous position. But it seems to me that whether you're looking at it through the possibility of the outcome at trial, or whether you're looking about it as to the likelihood that the government would not have dismissed the substantive Hobbs Act count had there been no plea to the Hobbs Act conspiracy. It seems to me it's one of those cases where all roads lead to Rome.
Absolutely.
And you come back to the same place, no matter which theory of prejudice you wish to use. I wondered whether you had one theory of whether you preferred one of those views of prejudice to the other, or whether you plead them both, whether you argue them both. What is it?
I agree with that, Your Honor.
What do you agree with? What is the prejudice here? I didn't understand your answer to this.
I apologize, Your Honor. My answer is that all roads lead to the same outcome.
Okay,
She
but
can't show prejudice.
so I thought that he said there were 2 roads. Is that right? Are those all roads?
I believe so, Your Honor.
And what are those 2?
Well, there's the 2 I mentioned before, and then there's the one Judge Wilkinson mentioned, which is, would we have dismissed the valid charge if not for the plea of guilty? And the answer is no, we would not have. We made that explicit in the plea agreement. We dismissed the valid 924C charge only because he agreed to plead guilty to a 924C predicated on conspiracy. And if that's the measure of prejudice, he cannot show prejudice. If the measure of prejudice is success at trial, he cannot show prejudice. If the measure of prejudice is a reasonable probability that he would not have pleaded guilty, he still cannot show prejudice because he has to show that it would have been rational to
Well,
plead guilty.
how do we know that he would have pleaded guilty? That's what's bothering me about if this hadn't happened, then this would have happened.
Well,
Because using that as a legal analysis, I agree with you that, this is and as Judge Wilkinson said, we've got a procedural bar issue, we've got a waiver, and we've got a guy who did some pretty bad things. I mean, really bad. So, it's complex,
yes.
but I'm really worried about us writing opinions based on if this had not happened, then this would have happened, then that would have happened. How do we know? Okay, logically, from the government's perspective, he would have been in a position where he was facing this charge and he would have had to plead guilty, but we don't know that. And I'm just worried about how the opinion is going to write if we go that route.
I understand that, Your Honor, and it's certainly a concern. I don't know that this court, I mean, I'll talk about, there's another way to answer this question if it's under the appellate waiver, but in terms of prejudice, because it requires actual prejudice from an error that occurred 10 years ago in this case, I'm not sure there's a way to avoid what if analysis completely, but the case law gives us some answers. When we're talking about prejudice in the context of ineffective assistance for counsel, we ask whether it would have been rational.
But Judge Keenan makes a good point in the sense that we shouldn't be stating definitively what this would have been or what that would have been, because you get into the crystal ball gazing by doing that kind of thing. And if you on the other hand, the reasonable probability test it requires a certain amount of forecasting, and any withdrawal of a guilty plea involves a certain amount of forecasting. But it does seem to me to phrase this and like, if this had happened, he would have been in this position. And that's different from saying, well, this would have happened, this would have happened, this would have happened, if. You just say, well, here's the position he would have been in. And then you draw the very practical conclusion from that.
We have, Your Honor, in this case, which is unusual, we have unusually good evidence of what the defendant would have done had he never been offered the opportunity to plead guilty to the indictment that contained, or the information. There's an information and an indictment in this case. He was given the opportunity to plead guilty to an information that contained the 924C predicated on conspiracy. And we know what he would have done with the 924C charge in the indictment, which is the valid charge. Because he told the district court twice under oath, yeah, I want to plead guilty to that, after being informed correctly of the elements and being read that charge twice under oath. And that second one especially was aborted because the district court said, are you sure, government, you want to make this deal? After that second one was aborted, the defense filed a letter with the district court saying, we didn't ask to get out of this plea. We think it can be worked out. We still think this is the plea. And all of that occurred at a time when the information, the charging document contains a 924C predicated on conspiracy, had not been filed. That wasn't an option on the table. So when the only option on the table was pleading guilty or going to trial on a 924C predicated on a substantive act, the valid crime, the defense said twice from his own mouth, and once through his attorney, and twice in written plea agreements, that he was indeed willing to plead guilty. So we have pretty good evidence, above average in most cases, that he indeed would have pleaded guilty. It also would have been objectively reasonable to, because in the light of his decision not to dispute the facts, he wouldn't have received acceptance of responsibility.
I suppose there's a general, excuse me, Judge Motz, go ahead.
All right. I can wait my turn.
No, go ahead.
I was just going to ask you, how do you figure in what we said in Adams, that a sentence based on a conviction that became erroneous due to an intervening law we have here can still do prejudice even if the sentence would not change?
Well, Your Honor, in that case, there was a conviction that would have been void, and the court went on in detail about how convictions are prejudicial even if there's no sentence that attaches to it because of collateral consequences and because of the special assessment. Here it's a different case because we don't have a situation where the answer would be, had this been raised before, the 924C would have just gone away. Had this issue been raised before, that 924C would have gone away, but another 924C based on the same course of conduct, same gun conduct, would have been in play. That would have, the same consequences would have attached to that. He would stand today convicted of a 924C, and he would stand today subject to that same special assessment because
They would be different crimes.
well, Your Honor, I'm not even.
Well, sometimes the government charges them in different counts.
They are in
You know,
different.
so if they're not different crimes, what are
Well,
the
they
government doing then?
They are, but Adams made this point too, is what we're talking about is whether they're under the same course of conduct. It defined factual innocence, and I'll turn to that issue now because even if there's no procedural default here, there still is appellate waiver, and cause and prejudice isn't an excuse for an appellate waiver. You need a miscarriage of justice in the form of actual innocence as defined by Adams. And I think Adams makes the fact that he committed another 924C predicated on substantive Hobbs Act dispositive. Because Adams defined factual innocence as it's impossible for the government to prove a violation of the statute. There it was 922G. Here it's 924C. And it was impossible in Adams because there was no 922G predicate, valid predicate in existence that the government could have proved. Here, in our case, we have a valid 922G predicate, or not, I'm sorry, 924C predicate that we absolutely can and would have proved had the defendant elected to go to trial instead of pleading guilty. So it's basically the inverse of Adams. And under Adams, you can't establish factual innocence. McKinney can't establish factual innocence. McKinney also went further when you're talking about specifically a 924C. It discussed what Boosley had said about 924C. There, the defense had pleaded guilty to use of a firearm in furtherance of a crime of violence. The government came back and said, well, then he needs to prove that he's innocent of carrying a firearm in furtherance of a crime of violence. And the Boosley rejected that because there was no evidence the government had foregone a carriage charge in exchange for that use plea. But here the evidence is uncontroverted and overwhelming that we forewent a 924C based on Hobbs Act robbery in exchange for his plea of guilty to 924C predicated on conspiracy. So he cannot establish actual innocence.
No, I don't. I think you're right about that.
Your Honor,
But I was back on prejudice.
Oh, I appreciate that, Your Honor, but the actual innocence is dispositive under the waiver.
Well, yes, the waiver is, there's Fourth Circuit law on the waiver and the other things that you say do away with this, but I don't think it's very helpful to you.
Well, I'm happy to address that, Your Honor. I'll go through what Ms. I'll answer anything this court wants, certainly, but I'll go through the decisions.
Well, could you address Cornett?
Sure, Your Honor. Cornett applied there's a well-established exception for sentencing above the statutory maximum, and Cornett applied that to a sentence error based on Johnson. Did not extend it to convictions, and really couldn't have, because this court's longstanding precedent going back to at least Willis in 1993, but before that, holds that you can waive the right to argue, well, my conduct is outside the scope of a conviction. Law is not that anything that's an error that would prevent the defendant from sentencing you is unwaivable. Otherwise, that would mean that the Supreme Court precedent saying an indictment is waivable or a jury trial is waivable would be actually unwaivable, because all of those things are necessary for the court to sentence somebody legally unless you waive them. The same issue attends Beck, which is even further afield. Beck specifically addressed a situation where the statute itself doesn't contain any offense of any kind of any sort. That's not what we have here, because 924C, everyone agrees there's some crime defined by 924C. Beck even specifically distinguished Willis and other decisions talking about, well, my conduct, where the argument is my conduct is outside the scope of the statute that defines an offense. So I don't think those cases.
How can a court legally sentence somebody who has been convicted of a crime that it's no longer a crime?
They can, Your Honor, only because of the waiver. Because the waiver makes that guilty, and you can give
Doesn't
up.
that make, I guess it gives me a level of discomfort.
I understand.
You know, that we'll check off on this case. I agree with you. The guy, you know, this is serious conduct here. But that we just check off on this case when we have somebody who was sentenced on for a constitutionally invalid.
I understand that
conviction.
concern very much, and I
Mhm.
think that is what the miscarriage of justice exception is designed to do, because it doesn't look at things like contract. It looks at things like, well, look, in the real world, do we have somebody who didn't commit a crime being sentenced and put in jail, even though they didn't do anything wrong? And that's what it's for. It's to solve that problem. But that miscarriage of justice exception doesn't help Mr. McKinney, because in his case, he doesn't have a miscarriage of justice, either in the colloquial sense of the term or in the legal sense of the term under Boosley and Adams. And for that reason, I think this court should affirm the district court's decision rejecting this 2255. I don't want to belabor the point. I want to mention one thing because it's so critically important. If you disagree with me about everything I've said or everything else here, I'd like to point out that the district court proceeded with jurisdiction over his original case.
It proceeded what?
With jurisdiction, with
Mhm.
subject matter jurisdiction over his original case. That's
I don't think we granted a certificate of appealability on the jurisdiction question.
that was going to be what I was going to mention. I can understand it arguably being antecedent to those. It's so important. I didn't want to sit down without mentioning it. We did address it in our brief. I think Supreme Court
So-
precedent is clear. And
Let
with
me-
that, if this
Right.
court has no further questions, I
Well,
will-
actually, I've got
Oh.
one.
happy to answer
um,
you.
So are you saying that if you've got a guilty plea, that cause and prejudice analysis doesn't really work as it ordinarily would? In other words, that you have to adopt a whole different analytical viewpoint?
Well, I don't know that it doesn't work. I think the fundamental questions are the same. Did you have cause in the sense that, were the tools legally available to you
Right,
to
right,
raise
but
the
let's get to
issue?
the prejudice. It
And on the-
seems to me that what you're saying is when you've got a guilty plea, you can use a different analysis. The what if. And that's okay because it was a guilty plea.
No, Your Honor. I
And
think-
you're saying, no, I think that it's more than that because we know exactly what he would have pleaded guilty to. We have a record. And that makes it different in this case.
I don't know. I think that makes it easier in this case. But I think the fundamental question, whether you have a trial, whether you have a guilty plea, whether it's an easy or hard question, I think the fundamental question is the same. Did he suffer actual prejudice from the alleged error? If the error had been ferreted out early on, would he be in the same position or would the outcome have been
But
different?
when we've talked about prejudice in this context, we've talked about the fact that you've been convicted of something that's not a crime. And
Yes.
that sort of has ended the inquiry.
That's a fair.
So nobody has said, and you must go and see if you could be convicted of something that is a crime.
That's true, Your Honor, but I think the reason for that is it's not been presented. In every single one of the decisions we've seen like that, and it's a fair point. It's a fair point in Adams, and that's the end of the inquiry because there's no other question. He was convicted, he was charged with one
Well,
crime.
we don't know that. We don't know that they could have had a record just like yours.
Oh, sure, but they would have had to raise we would have had to raise the issues. And if we didn't raise the issues,
I
then
mean,
that doesn't-
every now and again, the government. No.
I'm keenly aware, probably responsible for many of them myself. But when that happens, the court doesn't treat it as precedent. So the question,
No, but it's unusual since we have done a lot of these cases. This never come up, and a lot of these people are, as Judge Keenan said, really bad people that have been convicted of multiple crimes.
well, there is a reason for that, Your Honor. We don't raise either the procedural defenses or appellate waivers or post-conviction waivers as a matter of policy ordinarily when somebody only has a 924C predicate that's now Davis in. It's surprisingly rare that we have foregone an equally serious 924C charge or other charge in exchange for one. I thought it was a little bit more common than it seems to be. I think that's why you don't see many. But when you do see one, I think the actual prejudice inquiry still asks would the outcome have been the same. And I see my time is up.
So if there's no further questions,
No further questions. We
Did you want to address the 28J letter?
oh, certainly, Your Honor, I'm happy.
I'm just thinking you might want to have,
I'm happy to do that. Jackson, I don't think really helps the defense because it doesn't address a guilty plea scenario. And I did point out that the waiver doesn't, the validity of the appellate waiver doesn't turn on cause and prejudice. So he needs to show actual innocence for that. I think every other circuit that has addressed the issue squarely, some haven't addressed it squarely because they don't always assert the waiver, has held that in this type of a scenario where someone could be charged with, someone could have been charged and convicted of a 924C based on a Hobbs Act robbery, but they pleaded guilty to an invalid predicate under Davis. They're not allowed to escape their way. The court should join that emerging consensus. And so I ask the court to affirm the decision.
anything further? Judge Motz?
No, sir.
Judge Keenan, anything further?
no thanks.
Thank you very much, Mr. Enright.
Thank
Ms.
you.
Hester, you have some rebuttal time.
For the government, all roads lead to the question whether McKinney is actually guilty of equally serious dismissed charges, which is the Lewis versus Peterson case. But that analysis doesn't apply under Beck or under Jackson. It doesn't apply under Beck because this court has a long line of cases going back to 1992 saying that when the district court takes action without authority, that is outside the scope of an appeal waiver. And that applies to sentences, restitution, any action that the court takes without those outside of authority. And in this case, convicting somebody under a statutory provision that is certainly outside the court's authority because it lacks the authority of the U.S. Constitution to convict somebody under that statute. And that is the reason why the appeal waiver doesn't apply here. And that is totally separate and apart from any analysis of actual innocence under Adams. That is a totally different line.
But that's a legal innocence claim, isn't it?
It doesn't matter.
Bowsley says is not
It
enough.
doesn't matter whether it's legal or factual innocence because that whole line of cases under Adams is the miscarriage of justice exception to appeal waivers, which is a completely different line of cases than the Cornett and Beck going back to the Marin case, which talks about whether the district court actually had authority to take the action that it had. And this court has consistently held that when the court takes action outside its authority, that is outside the scope of the appeal waiver.
You're not going to talk about prejudice.
Well, we can talk about prejudice because again, I think that the government is trying to backdoor this Lewis versus Peterson analysis into the prejudice analysis instead of taking it outside of the actual innocence exception under Bowsley. And I think that we have to be careful to make sure that those two things are something different. And
Well, isn't the problem really in this case is that you're arguing prejudice is something different from what opposing counsel is arguing?
Yes, that's
I
definitely
mean,
true.
you're saying it stops with the fact that the court took action without authority. It imposed an invalid
Yes,
conviction and sentence.
yes.
And Mr. Enright saying, no, that's not the prejudice analysis. You look to the whole context of the multiple offenses, what took place in this case. So I guess we have to decide as a threshold matter, what is the prejudice? What is prejudice?
Well,
And why is your theory of what is prejudice correct and his is not?
correct.
But
But
do you have any authority that you could suggest to us who would first look to on that point?
Well, United States versus Garcia, which is the 10th Circuit case, which is unpublished, which says that an unconstitutional conviction is an actual and substantial disadvantage. And then, of course, there are lots of district court cases saying that as well. And I think that's one of the reasons why this hasn't bubbled up to the circuits already. But then a second point is like, we even have an alternative to that, which is if the standard is what Judge Wilkinson said in the guilty plea context, borrowing that from ineffective assistance of counsel, would this defendant have pleaded guilty absent the district court's mistake? We know from looking at the transcripts of the failed guilty pleas in this case that wouldn't have happened. And in particular, the second guilty plea hearing that failed, the reason, you can tell from reading that the reason it failed is because nobody had actually read the indictment until they got into court. And when the magistrate was reading that third count, he looked up and said, wait a minute, we don't have an agreement here, do we? And the prosecutor agreed, no, we don't have an agreement because this defendant is not willing to plead guilty to substantive hostile.
You know, I'm not sure, counsel, that you're asking us to confront a global question about whether there can be prejudice where someone has pled to something where the predicate is no longer valid in the sense that Hobbs Act conspiracy is no longer a crime of violence. But I'm not sure we need to pose the question in an absolute or global way. I think it really, all of these questions boil down, it seems to me, to a practical examination of the particular facts. And I don't feel, for myself, I don't feel a need to make, well, this can never happen or whatever. I think it depends on the facts of the case and how strong the case against the defendant is and what the terms of the plea bargain are and whether the parties spelled out their intentions to sufficiently and whether the facts of the case are in dispute. But I don't see this in global terms. I see it as a very practical inquiry hinging on the facts and circumstances here. And in light of those facts and circumstances, I must say, I think you've got a difficult challenge. But I wouldn't reject the challenge by saying, well, there can never be prejudice in a situation where a 924C predicate was subsequently ruled an invalid predicate. To me, that poses the question at a more general level than I feel it need to go. I just think that the thing that makes it hard from your perspective is not some large legal proposition, but the specific facts surrounding the plea bargain, surrounding the dismissed charge, surrounding the parties' views of their intention. It seems to me that there's a kind of thing where it's easy to go at it narrowly. At least I hope so, because I don't know that I feel comfortable with a very broad pronouncement. That's the difficulty I'm having. Is I think the facts are tough for you.
I think Judge Wilkinson has pointed out exactly what the difference is. And would you agree that we need to look at the facts to make the assessment about prejudice?
I think that is an alternative way to get to it. I do think that just simply the fact that he is convicted under an unconstitutional statute in itself is prejudicial. But I think alternatively, if the court is going to look at the facts, it has to look at the fact at the failed plea hearings in this case, because it is clear that the magistrate and the people involved did not think that Mr. McKinney was willing to plead. So I think that if the court,
I do remember your argument from before, but what I'm asking you is it equally valid to do the approach that Judge Wilkinson has so eloquently laid out, or is it your position that when we have a conviction that is subsequently not of a crime, that in and of itself constitutes prejudice, being convicted of something that's not a crime?
so I think that there's no controlling precedent either way.
Right.
So, I think that that's the court's decision to make. And our position certainly is that the conviction itself is enough. But alternatively, if the court looks at the record in this case, it is really easy for the court to make a one-off evaluation of the facts in this case, because they are so unusual with these two failed guilty plea attempts. It's clear that his lawyer was afraid that he was about to enter a plea that wasn't knowing and intelligent, and the magistrate judge was too. And they were just trying to be very careful to make sure that this defendant with a 10th grade education fully understood what he was pleading guilty to, and that's their job. And that's why the court pulled it in the second plea hearing when he read the count that didn't have both predicate offenses alleged in it and said, wait a minute, I don't think we have an agreement, because I don't think this is what the defendant thought he was going to do.
And so
Any further questions?
is that, how did that go to the next step? So how did
So
that?
the next step was they suspended the plea hearing and
Yeah.
let the parties get back together, because they're actually, the prosecutor at the second plea hearing was a duty attorney, not the attorney.
Go ahead.
Yeah, so anyway, so they needed to go back and talk to the attorney who's actually managing the case. And then after that second one, they worked out this process of the information to allow him to plead guilty to the conspiracy and the 924C predicated on the conspiracy.
I don't understand how that changes.
Well, what it
I'm missing
changes,
your argument. But
I mean, what it changes is it demonstrates that he actually really had a problem with pleading guilty to the substantive Hobbs Act robbery and the 924C predicated on it. And the court and his lawyer and the lawyers were just trying to make sure that he understood what he was pleading guilty to.
Thank you very much. I want to thank you, Ms. Hester, and Mr. Enright for your arguments. They've both been fine arguments, and we appreciate it. We will adjourn court and take a 5-minute recess before convening in conference.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.